What's up, guys? This is Berserkinarian. I'm coming at you with that swamp bottom style of life. You know what it is. The executive authority versus judicial authority. We're going to talk about separation of powers in the U.S. and in most U.S. Constitutions. Okay, police officers, executive branch can observe, stop, arrest, and issue citations, but cannot adjudicate or independently create legal binding criminal proceedings. Okay, and when you hear that, you go, okay, that's interesting. Judges or magistrates, the judicial branch, can issue a criminal summons or warrant based on probable cause shown under oath or affirmation. So, the legal principle here is a criminal case must originate from a verified complaint or probable cause determination by a judicial officer, not just a citation from law enforcement. Now, what makes this criminal case valid? Okay, to legally charge someone with a crime, the Fourth Amendment and many statutes, they require a verified criminal complaint, and specifically the one that we're going to mention here is CRR 2.1 in Washington, Rule 3.140 in Florida. A verified criminal complaint sworn under oath, a judge or magistrate's signature on a summons or arrest warrant, an arraignment date entered into the court docket, a traffic citation that alleges a criminal offense without a judicial signature or court filing is often constitutionally defective unless a magistrate later validates it. Okay, so in pertaining to this video, we're going to talk about traffic citations. Okay, because there are victimless criminal traffic citations that have civil penalties. And I'm not sure how that's legal. I'm confused. A traffic citation, a criminal traffic citation, try to bypass the rules. A police officer issues a citation for a criminal traffic offense like DUI, reckless driving, or driving on a suspended license. The citation includes a checkbox for language claiming it is a summons to court without ever being reviewed by a magistrate. So, you know, when you get like a speeding ticket, okay, on the side of that traffic citation, it's going to say you must appear in court, and if you fail to appear in court, a bench warrant shall be issued for your arrest. But most citations don't tell you no court date. But it's telling you that if you do not comply and show up and come to court, you're going to be arrested. It's a little bit ambiguous, discerning language there. That's an issue. A citation includes a checkbox for language claiming it's a summons to court without ever being reviewed by a magistrate, because a magistrate isn't the one that issues it on the side of the road. It's an officer, an executive branch member. The courts treat this as both the initiation of criminal proceedings and a summons bypassing the magistrate. The court, this creates a quasi-criminal process that skirts constitutional requirements, often under the justification that traffic laws are civil, regulatory in nature. Okay, the legal issue here, okay, and it's a big one, is the citation is not verified by a judge or a magistrate. It's not filed in with the courts, and it lacks judicial approval, period. Yet, it's used to compel a criminal court appearance violating due process. When it's issued and you go to court, you're guilty until you can prove innocence. And that goes against our Constitution. And last I checked, anything in the Constitution, anything that goes against a constitutional, that goes against the Constitution is null and void. An unconstitutional act is not law. It confers no right, it imposes no duties, and it affords no protections. It creates no office. It is in legal contemplation as inoperative as though it had never been passed. Okay, those are powerful words. While acts of de facto incumbent in office lawfully created by law and existing are often held to be binding from reasons of public policy, that's a very important point, public policy. It is often confused with the state's right of eminent domain of police powers. Police powers and public office are almost the same thing, except one is done without law because the powers to be want it to be, and the other is done because the state is claiming police authority to do so. Okay? Marbury v. Madison. All laws which are repugnant to the Constitution are null and void. Where rights secured by the Constitution are involved, there can be no rule or lawmaking legislation which would objugate that or abolish them. Miranda v. Arizona. Officers of the court have no immunity from liability when violating constitutional rights. Owen versus the City of Independence. And 16th volume of Am. Volume 2, 16th edition of the Am. Jurisprudence, Volume 2, Section 177 and 256. The general rule is that an unconstitutional statute, though having the form and name of law in reality, is no law, but is totally void. You know, the loophole via civil regulatory framing, okay? Most jurisdictions justify this by calling traffic laws regulatory offenses under the police power of the state rather than the true criminal law. The issue here is citations directly going through a magistrate treat you as guilty unless you contest it, okay? So unless you fight it in court, you're guilty automatic. They fine you or suspend your license administratively. This is constitutionally shaky when the offense is labeled criminal, yet skips criminal procedure and affords you no constitutional procedures, period, in a state court. Most of this is handled in an administrative court, which is a court of no records, which means when you go to appeal it, there ain't much that you can use to justify you appealing that decision. Okay, you're not even afforded a damn jury trial, which is afforded even in civil and criminal procedures. You're always afforded a jury trial. But when you go to traffic court, you're not afforded a jury trial. The judges, they'll tell you that. You're only afforded a bench trial, and I'll be your judge and your jury. You don't have no right to protections in administrative court. It's quasi-judicial. It falls outside the lines of Article 3 Constitution. All right? Key case laws and principles. Gerstein versus Pugh, 420, citation 420 U.S. 103, 1975. A neutral magistrate must make a probable cause determination for a criminal prosecution. Okay. Shadwick v. City of Tampa, citation 407 U.S. 345, 1972. Only judges or neutral judicial officers can issue criminal process, a warrant or summons. All right. The Fourth Amendment requires probable cause supported by oath and or affirmation before the state can issue a criminal warrant or equivalent. Okay, due process, your 5th and 14th Amendments. You are entitled to a fair notice and an opportunity to be heard, not to be coerced into court by an unverified ticket. All right, a police officer is not a judicial officer and cannot lawfully issue a criminal summons. He can legally issue one, just not lawfully. Okay, all true criminal cases must originate from a sworn complaint, information, or indictment signed and verified by a magistrate or judge. Okay, by issuing a criminal traffic citation directly, the state bypasses this safeguard, effectively initiating prosecution without proper judicial review. This amounts to executive overreach, violating the separation of powers, the Fourth Amendment, and the due process. Stay tuned for Section 2. I'm also posting on TikTok, but I got to do them in short increments. Because I want everybody to hear, you know. It's, to me, it's important. All right, let's get back to part 2. Okay. And, you know, we need to challenge jurisdiction and proper procedure, okay? And here's one argument. A traffic citation was not lawfully issued as a criminal summons because no judicial officer reviews it and signs it. Therefore, the court has no lawful jurisdiction over a criminal proceeding. And this is where I have an issue, and that I don't understand, is you can issue a criminal summons or a summons in the form of a criminal summons that has no criminality to it at all. You know, some of these traffic citations, like speeding, that have no, nothing more than a fine with it. You know, just a fine. That's a civil penalty. But yet you're in a criminal court. And the language on the paper is clear that you've broken a law. You know, so I don't understand how that quasi-judicial court hasn't been destroyed yet in the Supreme Court. And I don't understand how judges are upholding it unless they're being paid to uphold it. You know, the U.S. Constitution, 4th and 15th Amendments, Gearstein v. Pugh, a neutral magistrate must make a probable cause determination for criminal charges. Shadwood v. Tampa, only judicial officers may issue a criminal process. You know, we could motion to dismiss for lack of judicial authorization of criminal process. You know, we need to fight against it. I mean, there's clear issues with the vagueness and the phrasing of traffic laws, and there's a clear overreach of state powers when it comes to how they're able to control regulation. Yes, they're clearly over-regulating the roads. They pave as many roads as absolute possible, which takes away as many routes as possible from the citizens to travel privately. There's no question about that. Will the states fight you if you take it to court and try to get some of these roads back? Absolutely. They're going to fight you to the moon and back. Do we need to still fight that battle? Absolutely, because if we don't fight the battle, we won't ever win. And you know the only way to win is to fight that battle. You know, we need to challenge citation as unsworn and unverified, all right? A criminal charge must originate from a sworn affidavit or verified complaint. A traffic citation is neither verified under oath nor issued by a magistrate and therefore should not lawfully initiate a criminal prosecution. We can back that with criminal complaints must be verified by oath or affirmation per the 4th Amendment. State rules of criminal procedure. That's just the Utah rules of criminal procedure, Section 3. It's a due process violation. No formal summons or clear notice of argument against the argument. The citation functions as a de facto criminal summons, but was issued without judicial review, no court date set by the court, and no opportunity to respond through standard criminal procedures. Okay, so it's clear lack of due process. Your consequences: the defendant is forced to either waive their rights by paying the fine, or affirmatively requesting a hearing, flipping the burden of action onto the defendant without a lawful summons or arraignment, which clearly indicates that you are guilty unless you contest it and fight it in court, which goes against innocent until proven guilty. You know, Goldberg versus Kelly, 1970, the government actions affecting property interest, money, and license require notice and opportunity to be heard. And you see how much you have to go through in a traffic court situation to be heard. And it's crazy. You know, civil versus criminal conflict. You know, it's a clear conflict and argument. The state calls the violation non-criminal, yet imposes court appearances under the threat of default or bench warrants, monetary penalties and license suspensions, possible jail time for failures to appear or repeated offenses. Conclusion, the penalty system reflects criminal enforcement while invading constitutional criminal protections. A key phrase here is the government cannot impose criminal-like penalties without criminal due process. So, next time you're in court, ask the judge, explain to me how I'm forced into a criminal court without criminal procedure and criminal protections. Ask the court, ask the judge that. Ask the judge how that quasi-judicial court has the authority. Instead of just making some brandish comment or coming up with some sovereign citizen shit in court, do your due diligence and ask the judge to verify on record. Is he a criminal judge or a civil judge? Ask him, how is a criminal summons only carrying a civil penalty? Explain it. Because I don't understand how quasi-judicial systems are legal when they clearly shouldn't be. Like, when you're in court, the layman gets destroyed because he don't know the language of the court, right? A motion to dismiss is so big. If you can look at your citation and say, man, look at all these errors. You need a lawyer to file that motion. No, you don't. You can do it yourself. You could say, like if you were arguing, if you were a sovereign citizen in court and you're arguing against the quasi-judicial system and you want to file a motion that, the citation doesn't afford you Fourth Amendment due process, right? You could say something like this. This citation was not issued under judicial oversight or verified by oath or affirmation as required by the Fourth Amendment. Therefore, it cannot lawfully serve as a criminal summons, and any proceedings based on it is constitutionally invalid. And you could back it with any federal rules of criminal procedure. You can just go copy it right down and do it. But you could also use Gerstein v. Pugh, which is a neutral magistrate must make a probable cause determination for criminal charges. And Shadwick v. Tampa, only judicial officers may issue criminal process. And right there, you motion. You got to fight it. If you were just going into court today, you can make a comment like, Your Honor, I'm not challenging any facts today. I'm asserting the state is prosecuting an alleged criminal act without having followed constitutionally mandated procedures to invoke the court's criminal jurisdiction. The executive branch cannot issue criminal process. Only a judicial officer may do so. And they're going to argue with you a little bit, but, this is where you need to learn to argue. This is where litigation comes in. You study these court cases, and when you make this statement to the judge and you want it dismissed, well, you got to back it up. So you need to know Gerstein v. Poe and Shadwick v. Tampa, and you need to know every aspect of the case. So when the judge asks questions, you have a foundation of where you come up with this. Because that's the thing in court is you better have a damn good foundation to keep the burden of proof in the state's hands. Like I've told you over and over, you cannot win unless the state cannot prove burden of proof. If you can force the state to not be able to prove burden of proof, you can win. The ball has to stay in their court. The judge is just he's just the referee watching two jesters throw the ball back and forth, and whoever gets stuck with the hot potato is the loser. And you got to keep the state as the hot potato, okay? You got to make them hold it. So some strategic goals here is push for dismissal based on procedural defects, not on factual disputes. Okay, don't argue with them about shit. All right, shift the burden back to the prosecution to demonstrate the legal sufficiency of the citation as a lawful criminal summons. All right, preserve all objections for appeal. Even if the judge denies your dismissal, that's fine. You can object. Save it for the appeal. Just appeal. Don't get pissed off. Don't get mad. Demand a verified complaint, judicial summons, and officer's affidavit. All right? This forces the prosecution to show how the case was lawfully initiated. If the judge won't dismiss, Here's your position for appeal. Constitutional violation of criminal procedure rights. No verified complaint or judicial determination of probable cause. Unlawful criminal process initiated by executive officer. And lack of meaningful notice and opportunity to be heard under due process standards. Okay? And all you got to do is something as simple as ask questions. Ask the judge, are you a criminal judge or a civil judge? Is this a criminal citation or is this a civil citation? Because if I'm in a criminal court with a civil citation, then I need to have civil procedural rights. And if I'm in a criminal court for a criminal summons, then I need to have criminal procedure rights. If not, I want it dismissed because I'm not getting either one here. That's your argument. Quit doing the sovereign citizen crap. Fight them with their own words and their own phrases. Fight them with their own language. That's how you win. It's Berserkinarian. I'll get back with you with another video. I got to go tend to some stuff. Y'all know what it is. It's that swamp bottom style. It's that possum butt. So look, let's get on down. Let's learn a little bit. Like and subscribe. Follow my page. I'll keep dropping legal videos as much as I can. I thought I had court today. Turns out they give me the wrong date. They told me the 12th. It's actually the 19th. I was like, well, that sucks. Another day. Okay. But anyway, a lot of what I'm posting has to do with me going to court and learning. I'm learning, teaching myself how to litigate. I watch videos. I interact with AI, back and forth talking, trying to learn the legalese language, trying to learn litigant tactics for traffic citations, and like every other sovereign citizen, I want to be able to drive down the fucking road in my automobile without a goddamn license, and register my vehicle every year and pay fucking property taxes on something I've already bought. I'm just like you. I hate that shit. But the fact of the matter is, I'm realistic about it. We're not going to win with the bullshit that y'all come up with. We're not. We're not going to win at all. We're going to lose, and we're going to continue to lose in court. And the more that we lose, the more they're going to change up the language so that way we can't win. We have to defeat them while the language is still available. And the language of the court system is clear and defined, and we need to fight. So like and subscribe. Let's work together. Let's start a tea party. Let's take over. Let's use that Constitution for our own liking. Let's take over these states. Let's hit them with these quo muertos. Let's take them out. Let's hit them with legislative changes. Let's go to court and take them for, let's go to court and challenge bad language. Let's go to the politicians and show them, these courts are using our own tax dollars to create laws against us and take away our freedom of rights. We need changes. We need it here. We need it there. Let's keep talking. Let's keep working it out. Leave a comment below. You know I love you. Stay tuned and follow God, baby.